If you have been charged with felony domestic violence, probably one of the things that you are thinking is, how can I get this thing dismissed? When can I get this thing dismissed? So in this video, I'm going to be going over the 5 times that your felony domestic violence charges can be dismissed. My name is Veronica. I'm a domestic violence defense attorney here in California, and I help people put their cases behind them so that they can enjoy their lives and their freedom. Okay, so let's jump right in. 5 times that your felony domestic violence charges can be dismissed. The first way is before court. So especially if this is your first time ever being arrested, and first of all, you are probably thinking, oh my God, a felony. My whole life could be over. Slow down, that's probably not true. And if you look at a lot of lawyers' websites, you are going to see that you are facing, usually it's up to 4 years in prison for felony domestic violence. That's extremely unlikely to happen if it's your first time. In fact, you may be able to have an attorney get your case dismissed before court. Now, it's really important here that they actually take action. Many attorneys will just wait for the first court date. But what you want to do is submit to the DA your side of the story, all the good things about you, hardships you've experienced, character letters. If the victim is on your side, how about a letter from the victim? Because otherwise, when the DA is reviewing this case and deciding if they're going to file charges, and if they're going to be more serious charges than what you were arrested for, less serious charges, or if they are just going to drop the whole thing altogether, which is obviously what you want. If you don't do anything, all that they're going to be looking at is your police report and your criminal history, or if you've never been arrested, your lack of criminal history, which is something going for you. But what they don't know is that you have a lawyer who's representing you. You're not just going to take the first deal. You're going to fight this thing, right? And what about all of your background information, all the good things about you? They're not going to know that unless you tell them. So it's really important before court to have an attorney contact the DA's office and try to get charges dismissed. At my firm, we are giving people the news that their cases were dropped before court on generally at least a weekly basis, and depending how busy we are, sometimes on a daily basis. Last week, we had 3 cases that were dismissed. And of course, that's not a guarantee. Every case is different, but that is one of the big times that your case can be dropped before court so that you can get this whole thing finally put behind you. Number 2. The DA can dismiss the case even once they have filed charges. Now, obviously, this is going to be a little bit more difficult, but if your attorney can successfully convince the DA that there are problems with the evidence, that you are a good person deserving of a second chance, that there's some motion that they could file that potentially could get the entire thing thrown out, or some combination of those, likely some combination of those things, then the DA will sometimes voluntarily dismiss. Now, they may want you to take some domestic violence classes, but if it's in exchange for a dismissal, my advice to any one of my clients, the advice I would give to my little brother if you were in that situation, and the advice that I would take is I'm doing the classes. If I can have a guaranteed dismissal, not have to go through the time, expense, stress, and risk, most importantly, of trial, I would definitely take those classes if the DA is willing to dismiss. Number 3. At the preliminary hearing. So if you have felony domestic violence charges and they are actually filed against you and they are filed as a felony, not a misdemeanor, then about halfway through the case, there's going to be something called a preliminary hearing. A preliminary hearing is a probable cause hearing where the state, the prosecution, has to prove to the judge that they have enough evidence to proceed to the trial stage. What is the standard of evidence? How much evidence? Enough to support probable cause. So that's the same standard that the police use to arrest you. So you know firsthand in this case now that it doesn't necessarily take a whole lot of evidence. However, at the end of the preliminary hearing, if the judge does not hear enough evidence, so let's say that the victim doesn't testify, the cops can still testify as to what the victim said, as to what you said, as to what they saw and heard. But if the cops testify, for example, that there was a neighbor who called and said that there was a loud argument, they came out and the 2 of you said nothing happened, but they just arrested one of you anyway. Well, as long as you have a judge who's halfway awake, and not all of them are, but as long as you have one who's halfway awake, they may actually dismiss the case at that point. Number 4, if your lawyer files and you win, a motion to suppress and a motion to dismiss. So a motion to suppress in this case, in the domestic violence context, generally would be based on statements that you made as the defendant. Now, a lot of people will say, well, they didn't read me my rights. The case should be dismissed, shouldn't they? Well, it depends. Were you in custody and being asked questions by the police and then you made these statements? When people say they didn't read me my rights, the first thing I will ask is, well, did you say anything to them? Because if the answer is no, then there is nothing to suppress. How it works is that if you are in custody being interrogated by the police and you make incriminating statements, then those statements can be tossed, can be suppressed if your lawyer files a motion to suppress. Now, I said motion to suppress and motion to dismiss because let's say that you did make incriminating statements and you were handcuffed. Maybe the police hadn't formally said that you were arrested, but you didn't feel free to leave, and there's so much case law on this. But handcuffed is pretty clear that you are not free to leave, right? And the police are asking you questions at that point. They should have read you your rights. Now, let's say your lawyer files a motion to suppress and all those incriminating statements that you made go away. Now the question is there still in the case enough evidence for them to proceed? If the only evidence that they had against you were these incriminating statements, and I know it sounds kind of silly that this would be the only evidence, but it happens. For example, let's say that you were afraid that your partner would be arrested, and maybe your partner has immigration issues, or your partner is the one with a good job, but the breadwinner, and so if one of you is going to get arrested, you'd prefer for it to be you. So your partner says nothing. And you say, yeah, it was me. I'm the abuser. I committed domestic violence. Arrest me. And they do. If that's the only evidence against you, there are no marks. There are no injuries. There was no neighbor who heard an argument that sounded like somebody was being physically abused. Then the case can potentially be dismissed. Number 5, at trial. Of course, where all this is heading, if the state is not willing to dismiss, they file charges against you. If you say, look, I'm not taking a deal in this case unless it's a dismissal because I would lose my job, for example, or because I didn't do anything wrong, then the case will ultimately go in front of a jury and there will be a jury trial. Now, I say jury trial, but you could have a bench trial where you have a trial in front of a judge, but generally in criminal defense, the defense does not want to do that because our chances are better, generally, in most cases, if 12 people would have to agree that you're guilty in order to convict you instead of just one. And a lot of judges are former DAs, so we don't necessarily want to just put your fate into their hands. But of course, trial is expensive, and as I mentioned, it is risky. So generally what you want to do is explore options number 1 through 4 as fully as you possibly can before you consider going to trial. Because risky, meaning that if you do get convicted, well, then the judge is going to sentence you. And then even though generally for a first-time domestic violence case, you wouldn't necessarily do jail or prison, the judge could sentence you to prison. The judge could sentence you to jail, and you have no leverage at this point. You have no control anymore. And so that is very risky. I hope you found this video helpful. If you do have a domestic violence case in California, feel free to give me a call. You can find my number down below. You can also book a consultation there. And if you did find it helpful, please don't forget to like, subscribe, ring the bell, and follow me on Instagram, TikTok, and Facebook.